would you join us, and Ms. Miller?
Good afternoon, Your Honor.
Good afternoon. Our sound system has worked momentarily and then it went out. And now it's out. So I've got headphones on, but we're going to address your case. And thank you for being here on short notice. This is Southwest Michigan versus Mitchell Cripps, 26167 LT. Mr. Stephen Smith is here on behalf of the plaintiff, and Savannah Miller is here as a power of attorney for Mitchell Cripps. We lost Mr. Smith.
I'm here. Can you see me?
Oh, there you are. I set this on very short notice. Ms. Miller, you filed this motion.
Correct.
But you don't have any legal standing in this matter. You are a power of attorney, which gives you the right to hire an attorney for Mr. Cripps. It does not give you the right to appear as his attorney. And so you filed this motion. I set it for a hearing. I was hoping either he would be here or an attorney would be here, but you can't represent him in a contested landlord-tenant matter.
Yes,
do you concur, Mr. Smith?
I believe that is the case, Your Honor.
All right. Where is Mr. Cripps presently housed?
he is housed at 403. Can I say something, Your Honor, as far as the representation? I've engaged with Michael Mahoney. He will be retained as of 2 p.m. on April 7th of 2026 and will file with the courts his limited appearance. He also asked me to reiterate that the Michigan Court Rule 2.612C permits this court to relieve any party of judgment based on fraud, misrepresentation, and misconduct of the advised party. Third, he told me to state that on the same day of the sheriff's sale, the mortgage foreclosed.
Stop. He can say this because he's a lawyer. You can't. That gave you the right to hire a lawyer. You didn't hire a lawyer. You're doing the best you can. Now,
Yeah, I am. And we did. He can do unlimited appearance as of tomorrow at 2 p.m. We did hire an attorney on this.
who is this lawyer? I'm unfamiliar with him.
It's Michael Mahoney out of Lansing, Michigan. His number is P71428.
Mr. Smith, what's your position here?
I tried to lay it out in our opposition. I'm frankly happy to have you here, Mr. Mahoney. Tomorrow I can reappear. I think this is
it's great for him. I have court set. Sorry, I'll be available tomorrow at 2 o'clock. I can't be there at the time you scheduled it. So you drop everything you're doing tomorrow at 2 o'clock. I don't have time to do this tomorrow at 2 o'clock. I don't have time to do it Wednesday at 2 o'clock. I don't have time to do it Thursday at 2 o'clock.
Your Honor, that's what I meant when I said 2 o'clock. Tomorrow, he was available to represent us as of 2 p.m. tomorrow.
Well, the hearing is at 3:30 today.
Yes. He kind of took our case with a full docket. We're thankful for him. This was something that was a very short notice, and to retain an attorney after speaking financial aid and the process of that. And I'm doing the best I can with this. I really am.
Well, Mr. Smith filed a 41-page response to your motion for an emergency stay.
Yes. I guess I'm just asking the court if we could have a 14 leave to file an answer and counterclaim on the motion.
You're alleging fraud and misconduct. And they're contending they went through all the lawful steps to foreclose on this house. And Mr. Cripps got plenty of notice, wasn't able to make the payment, and is subject to a foreclosure. Sheriff's sale took place, it wasn't redeemed, and they're asking now to take the property back. Essentially, Mr. Smith, that's your position?
It is, Your Honor.
I'm debating on how to do, I'm inclined to grant your request. However, what I think what needs to be done is he needs to move. They're doing this stuff to try to forestall the foreclosure action. But I don't know anybody's making any effort to vacate the premises. We had a hearing. I granted the relief requested. Plaintiff filed an emergency motion to stay the eviction, which I granted, albeit on short notice, because I'm leaving on a trip. And in essence, they're defaulted. Mr. Cripps isn't here. There's no legal counsel here on behalf of Mr. Cripps. His power of attorney is here. So I guess it isn't a default, but the power of attorney doesn't have the right to speak for him as an attorney. The mortgage foreclosure sale was January 12th of 2026, more than a year ago. The sheriff's sale was July 10th, which is then the defendant gets another 180 days to redeem it. So it appeared to me that the plaintiff complied with all the requirements for purchase under a sheriff's sale and foreclosure. I'm going to grant plaintiff's original motion.
That's 3 more. Should be like 3:54 o'clock.
All right, thank you. Motion for emergency stay is denied. If Mr. Mahoney is going to get in here, he can file an appearance and actually file some pleadings rather than give you a court rule to recite. They've been attempting to foreclose on this property for several years. It doesn't just happen instantaneously. I suspect no payment has been made on this house in several years. And then they went through the sheriff's sale or the foreclosure action last January the sheriff sale last July. It's now April of 2026. And so, motion denied, the original order stands. If counsel files something, we'll set it for a hearing.
Thank you, Your Honor.
What is it you claim that they didn't do correctly?
So on the day of the sheriff's sale on the mortgage foreclosure by the lender on Mitchell Cripps and myself were approached by Kyle, an employee at Southwest Asset Management, informing Mitchell Cripps was to be vacated off the property right then and there. And if he wished to stay, that we could enter a land contract with Southwest Michigan Asset Company. During that time, there was a signature on a quitclaim deed converting all interest of the property, equity interest, and the right to redemption was all done on February of 2024. Subsequently, me and Mitchell were informed by Kyle Hamilton that the land contract payments could be tendered in cash sent to P.O. Box 18 of St. Joseph County, Michigan, starting April of 2024, which we did that up until we received a filing for foreclosure.
All right, so there may be fraud in here. I don't know who this Kyle is or whether he has standing to enter into a land contract for property that's owned by somebody else. At any rate, I have denied your motion for emergency stay. The original order stands. If plaintiff seeks a writ of eviction, I'm probably not going to sign it immediately, but if your attorney's going to do something,
yes,
they need to do something. All right. For now, your motion is denied.
Okay.
All right, thank you.
Thank you, Your Honor.
All right. The Trammels are here. Their attorney, Luke Knopfsinger, is here. We continue this matter from March 27th. According to the Trammels, through today's date, you owe $5,050 in rent. Your indication is you are going to try to get some emergency assistance and pay this rent, but it is significant. Do you agree with that number?
I do, Your Honor.
All right. You have 10 days to pay this or you're subject to being evicted. I'll explain this a little further. But through today's date, you owe $5,050 in rent, $167.64 in cost for a total of $5,217.74. You have to pay that amount within 10 days of today, which would be April 16th, or you're subject to being evicted. A partial payment will not prevent the writ of eviction. You had mentioned that you were trying to get some assistance from DHS or Keystone or some agency. Let's say they give you $3,500. That would still leave you $1,550 short. Well, actually more than that with the cost. You have to pay the entire amount to cure it. Next week, there'll be another week's rent due, which will be added into the equation. The Trammels do not have to evict you on April 16th. They have 56 days from today's date to ask for the writ of eviction, and 56 more days to serve it. So they have discretion, but they don't have to. At this point, they may wish to just cut their losses and get you out and get somebody in that can pay the rent. That's within their discretion. If you do move, you need to turn in your keys and give your forwarding address within writing within 4 days of your moving. Have you heard back from any of the funding agencies?
Not yet, I haven't, Your Honor. I called him Thursday.
Do you have a plan B if you do have to move?
There is no plan B. I mean, live in a vehicle.
Are you still at Fiber Converters?
Yes.
But you haven't even gotten your first check yet, so it's gonna be a long time before you got a lump sum. As I indicated, they have 56 days from today to ask for the writ and another 56 days to serve it. So they do have some discretion and they can rely on the advice of Mr. Knopfinger for that. But I find that you owe through today's date, $5,050 in rent, $164.74 in court costs for a total of $5,217.74. For the Trammels, I think this is the first time they've actually been all the way through one of these. It's very helpful to have counsel who does this to help with these matters. Some of the landlords are pretty good at it, but some struggle. And if you're new to it, it makes sense to have an attorney to help you. The rules are hard to negotiate sometimes, and they've changed. Anyway, this is a simple case of you either pay the rent or move out. They have some discretion to work with you, but that's an awfully large arrearage. Even if you paid $100 a week extra to catch up, it would take a full year for you to catch up. Again, if you do move, you need to turn in the keys and give your forwarding address within 4 days of your moving. If he has not paid by the 16th, you contact Mr. Knopfinger. They can apply for what's called a writ of eviction or writ of restitution, costs $15. And that's when the sheriff comes and puts your stuff out in the street. And that's not good for all concerned. Anyway,
No.
you need to contact with Mr. Trammell and let him know what your intentions are. You're gonna get a copy of this order, which you can share with DHS or Keystone or any funding agency to show the date and the amount due. But the amount goes up every week. There's an additional week's rent due. Do you have any questions, Mr. Frederick?
No, I don't, Your Honor.
All right, Mr. and Mrs. Trammell, do you?
No, no.
All right, Luke, here's your order and you're good to go. All right, thank you both. Thank you for helping me with my sound problems. All right, good luck to you, Mr. Frederick.
Thank you, Your Honor.
Singh versus Carrie A. Harris, 106 Maple, apartment number 1. This is a second hearing. We were here on March 27th. This was filed as a termination of tenancy action. Mr. Singh wants her to move. She indicated she has nowhere to go. We continued the matter. Rent was last paid, I think, in January, but he's not asking for the rent at this point. He's just asking to terminate the tenancy. Is that correct, Mr. Singh?
Yes, Your Honor.
Ms. Harris, have you had any luck finding any place to go?
No, Your Honor, I'm still actively looking. There's no place. I call every day. I'm not sure, and that's why I was wondering if I could maybe possibly get a little bit more time so I don't get thrown out on the street. I am presently, I mean, I have the rent money. I have rent money. I have a full-time job. I mean, it's not like I can't not pay my rent, but I just am having a really hard time finding somewhere for me and my dog to go. And I mean, it's rough. But I'm trying. I definitely am trying. I try every day.
All right. It is rough. I hear it every week. Twice a week, 10 times a week. People would move if they had somewhere to move to. You're doing better
Right. Well,
than
I
many
know.
people, or you have the money and you have a job.
Right.
But he's been trying to get you to vacate since January, I think. We're now into April.
Yeah, Your Honor,
Uh,
like I said, I'm trying. I mean, I can't.
All right, let me repeat this for both of you. I find that he is subject, or after hearing, the landlord has the right to recover possession of the property within 10 days, which would be April 16th. That's also the date you have to appeal this. He does not have to evict you on April 16th. Mr. Singh, you have 56 days from today to ask for the writ of eviction.
Sure, sir.
But by the letter of the law, Ms. Harris, he can ask for this on or after April 16th. No money judgment is that. I'm also telling you that when you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. Beyond that, I don't know what else to say. Hopefully you can find a place to go to. It's Mr. Singh, it's not great to do a eviction. It puts their stuff out in the street and it's a mess for all concerned. So if they're in the process of vacating, it sometimes makes more sense to just wait. But after the 16th, you can ask for the writ. Ms. Harris, I wish you the best of luck, but he's followed
Your
the
Honor,
steps to get this property back. If he is going to sue you for money, that will be at another hearing. You'll have a chance to respond. And I'll take testimony under oath to see who owes who any money. But at this point, I've granted him possession of his property 10 days from now.
Thank you.
Your Honor,
Thank you. We're going to return to file 26432LT, Enchanted Glen versus Janie Gibson. Miss Gibson is here with a number of moral supporters from Family Treatment Court. Mr. Gary Popovitz is here on behalf of the apartment complex, and their manager, Kim Snow, is here. We went through some struggles last week, and I think we determined that rent was $591 through March. Plus costs, it came up with $865 plus a late fee was $925, but now we're into the month of April. So Mr. Popovitz, what's the current arrearage?
I may defer to Ms. Shaw to explain, but her and I spoke this morning, and the current amount due is $412. Current monthly rent is $60, and then the ledger currently is a reduced amount from what you went over. Your number that you went over, though, is consistent with the notes I had prior to speaking with Ms. Shaw this afternoon. She had updated me on some of the third-party contacts and some other efforts that had been sort of discussed or being made at the complex was aware of as to Ms. Gibson's efforts here. But we have a rental amount of $412. Kim, before you elaborate on that or confirm what the ledger says, I will also remind the court, as the court indicated, we have court costs, and the court costs are a filing fee of $130, court's mailing fee of $13, service fees of $56.45, and then the statutory attorney fee of $75. So those court costs are $274.45.
Ms. Snow, rent through April, you claim to be $412?
Yeah, and when I pulled up the ledger this morning, Your Honor, they gave her a max rent concession of $239. Excuse me. So it took it down to 412, not including her court costs and all the other fees.
All right, so if we add up 412 through April, plus the court costs of 274.45. You get 686.45.
Correct.
Is that doable from the treatment court?
Sorry, what was
That amount, 686.45?
Yes, the same amount that we have.
All right, very good. Ms. Gibson,
Yes.
you're doing better. You're in a good program. You got support. The company looks like they've given you the max allowance that they can, some even additional reductions from last week. And your rent is $60 a month. People would love to have $60 a month rent. So it's important to keep you in this tenancy. I guess we're all in agreement. Mr. Popovits, I would ask for a judgment that says rent is 412 through April, court costs of 227.45, total amount 686.45 would pay your rent current through the month of April. Then when May comes, your rent would be then continued at $60 a month.
Judge, can I add something?
Yes?
I'm sorry. The amount that we have, we do have the same amount that Ms. Shaw has stated. She sent over the letter today. But it has not been determined that the team and the family treatment court judge are in a position to necessarily pay for all of the back rent that's due. We do have a court hearing on Thursday. It's our normal family treatment court team meeting prior. So we were hoping to be able to discuss this with the rest of the team and the judge.
All right. The person speaking wasn't identified on the record. I'm not sure she was heard. It's Melissa Bliss from the Family Treatment Court, among many of her other duties. So you're going to be responsible for this, whether they pay it or you get other funding source or you pay it. But it's in everybody's interest to keep you in this tenancy. If you get evicted from subsidized housing, it makes it difficult or impossible to get into it again. You're not going to find a nice apartment like this for $60 a month. So it's important you stay in contact with your manager. Now, they don't have to evict you. 10 days from today would be April 16th. They have the discretion to work with you for up to 56 more days before they ask for the writ of eviction. But I think what they would do, they'd like to do within the month of April. Defendant has family court treatment plan meeting on Thursday. That would be April 9th. Mr. Popovits, anything to add?
No, Your Honor, thank you. I appreciate all of the clarifications that have been made to the tenant. We will submit a judgment consistent with the information provided to Your Honor today and follow up with Ms. Shaw, depending on the status of things on the 16th. And certainly we wish Ms. Gibson the best of luck, and she should stay in contact with Ms. Shaw, or those advocates for her should, to advise as to the developments, because while the complex may choose to work with her, they won't have to after the 16th, but certainly this is a nice opportunity for Ms. Gibson. And if she's getting assistance, Ms. Shaw will relay that to me, and we will not file an order of eviction until we're confident the complex believes that's the best thing to do.
Thank you.
Ms. Gibson, do you have any questions?
No.
All right, well, let's hope this works. All right.
Thank
I
you.
have a couple of extra criminal cases to address. I'm going to dial them up.
Thank you,
And
Your
thank
Honor.
you, and thank you all.
Thank you
This
again.
is an extra pleasant source of funding to keep people in a residency such as this. All right, we're going to, thank you.
Thank you, everyone. Take care. Good luck to Ms. Gibson. Thank you, Ken.
All right, thank you.
Thank you.
This is a claim for $1,200 your contention is that you provided money to Cottage Care to do services, and they never did the services and never returned the money. Is that correct?
That's correct.
Is somebody in that second room?
Yeah, somebody's actually in the first conference room. There's somebody in both rooms.
Oh, they're in the second room?
These people are in the first
All right.
conference room.
I was gonna try to fit the criminal case in at 12:45 or 2:45, and I didn't make it. So that guy's just sitting there in the jail. All right, well, no one has appeared on behalf of Mr. Wenzel. We've kind of stalled around a little bit. He isn't here. By default, I find that he owes $1,200, pretty straightforward. He was paid money to perform services, didn't perform the service, and didn't give the money back. Had a guy in here within the last week or two who said he worked at Cottage Care. So the company, I believe, is still in business. All right, I find that he owes $1,200 plus court costs of $66.25. As I told the last person, Mr. Kwiatkowski, getting the judgment is the easy part. Getting the money sometimes is much harder. Although Mr. Wenzel's local, the business is local, I think if you're diligent, you can actually collect on this. Perhaps when he gets it, he'll just pay it and it'll be over with. That would be great. If he does not, after 30 days, you can do what's called a discovery subpoena, where you come to the court, they will do a subpoena that compels him to come to the courthouse and provide information like his bank account number, the registration numbers for his vehicle, his social security number, where you can garnish his wages or seize property or seize money out of his bank account. That often gets a response. And if he doesn't show up for that, he gets a bench warrant, and we set the bond at the amount of the debt. That almost always gets it paid. Let's see what kind of service I have here. Well, Judge Pattison has completely moved to the other side, except doesn't have anything hooked up. So we're sort of disconnected at both ends, and service by certified mail, signed for by Tyler Wenzel. All right. I entered the default in the amount pled for, $1,200 plus costs. The court officer will take you out to the counter. You can get a copy of the order. If he pays in 30 days, good luck. Great. If he doesn't, after 30 days, you come in and ask for a discovery subpoena, which will compel him to come in and answer some of your questions under oath. Why don't you take all these? All right. All right, you're good to go, sir. Do you have any questions?
I guess that would do me. Thank you, Grant.
All right, thank you. This matter, it's an odd posture, but the title of the case is Linda Kowalski versus Philip Kowalski, care of Michiana Guardianship. Linda Kowalski, I believe, is in Kalamazoo. Philip Kowalski has a Cassopolis address, but the property issue is here in St. Joseph County. And so, Ms. Kemple Johnson, you're here on behalf of Philip Kowalski and Michiana Guardianship?
Yes, Your Honor.
All right, well, I don't think I need to go through the advice of rights for a tenant. The tenant isn't here. Mr. Ryan, perhaps you could set out the premises for me here.
Yeah, I'd be glad to. So Linda, she's living in well, Linda presently is in Chicago. She's inpatient, undergoing treatment for cancer. Because of that, she has obtained the guardianship for her dad. And she will be returning from cancer treatment in the next few weeks. I don't think she knows the exact date, but it is soon enough. Upon her return, she's not in a situation where she can care for her dad, Philip, who is in his 90s, I understand. So it's probably important to get Mr. Kowalski to some other living situation where he can obtain the care that he needs, so that she can return to the house and not, among other things, have conflicts with her dad, Philip. So that's
who owns the house?
Well, she owns the house. So she was she had a career in the Navy. She retired from the Navy, I think she said about 10 years ago. She then bought the house from her parents, got a mortgage, paid them off. She stayed in the house. Her mom passed before 2020. And then she continued to care for her dad. But she and her dad continue to have conflicts. I don't know any details about their conflicts, but now she has this cancer diagnosis. She's in Chicago for a total of 7 weeks. Her dismissal is pending, and we need to get Philip to a better place, and because she's not able to care for him.
All right, why isn't Philip here?
Philip isn't here today because Michiana guardianship is here, and as Brian just mentioned, he is an incapacitated individual.
Okay.
We would request that the court does appoint a guardian ad litem, or at this point, a friend of the court.
Boy, this isn't your fault. Laura, can you do anything to remedy this? My sound here is just dismal. Would you repeat what you said? He's an incapacitated individual.
Yes, he's an incapacitated individual, and so under Michigan Court Rule 2.201E.
Take that off, but then it reverbs.
And you turn the volume up here.
I turn it up and then it will reverberate.
Okay.
We'll get bad echo. I don't know if anything you could do at the main station. All right. So is there a plan on what to do with Philip?
Well, Your Honor, right now, we would request that there is a guardian ad litem appointed. We have some concerns about the service of the notice to quit and the service of the complaint to begin with, as he is an incapacitated individual, and we would like some time to go through and answer that summons and complaint. As Mr. Ryan mentioned, this was Mr. Kowalski's home previously. He gifted it to his daughter, as my understanding, and we have a 94-year-old individual here who we need to get placed in the proper facilities, and we would need additional time along with that, as well as the potential procedural issues that we have here with service not being made on the guardians themselves, but rather being completed.
Is there any effort to place Philip somewhere else?
I believe Michiana guardianship.
I'm having such a difficult time hearing you. And it's not your fault, but I'm struggling to hear your eloquent argument here. But so if you bear that in mind.
Yes, Your Honor. I believe Michiana guardianship can speak to the current efforts being made to place him.
What can you tell me about that?
Yes, Your Honor. We are working on getting him placed into a long-term care facility. We are waiting on proper documents from his primary care doctor in Sturgis, and we've been working on this since February. So as of today, I have printed off the documents that the doctor's office is requiring, that are required by the nursing home. So hoping we can get that completed and we can start getting other locations for him to go to, because Fairview Living is where I sent the referral to, but they don't have any open beds for right now. So we'd like to continue looking in St. Joe County for a placement.
All right, well, the law requires that I adjourn this matter at least 7 days. And as it turns out, I'm going to be going on a trip. And I won't even be back. I lose this Friday the 10th, next Monday the 13th, next Friday after that the 17th, and April 20th. So I don't even have a date to utilize until April 24th. Which may be fine here. It may give people enough time to work out a plan.
Your Honor, were you able to hear the concerns about the service issue?
I'm sorry, say that again.
Were you able to hear our concerns about the service issue?
You did say you were concerned about service and there were some procedural issues, but you're here. So service of notice of the hearing or service of the original notice to quit?
Service of the original notice to quit, and more specifically the summons and complaint. We would just like a bit of additional time to answer said complaint.
Yes. Can you answer that by the 24th?
I believe so, Your Honor.
Well, let's pick a time. How was 11 a.m. on Friday, March 24th?
I am available, Your Honor.
That's fine with us, Your Honor.
I can make that work. I've got it up at 10 a.m., but I'll have someone else appear on my behalf.
All right. I have a difficult case coming up later this afternoon with an interpreter. And nobody in the case speaks Spanish. I mean, speaks English. I'm the only one that speaks Spanish. It's going to be very difficult. All right, April 24th at 11 a.m. Defendant has until that time to challenge service of summons and notice to quit. The fact that you're here responding to it makes the issue of lack of service of summons less compelling. If there is an issue regarding a notice to quit, that could be an issue regarding timing. But it sounds like he needs to be somewhere other than this. Does he have home health care in there, or he's just...
Your Honor, He has counsel on aging that is coming to his home to help clean and to take him to any medical appointments he may have.
Well, I don't know how we define incapacitated. Sounds like he's capacitated enough to live at home with home health care, but not capacitated enough to come to court. So I don't get a sense of him, but his guardians are here and his lawyers here. So I think that people would know for his interest, but I won't get a sense of his current capabilities.
He's more with it than most 94-year-olds, I can tell you that. He's amazing.
Well, I don't know very many 94-year-olds, but my father-in-law lived to be 96 and a half, and he said it wasn't for sissies. 70 and a half looks kind of rough from here.
Right.
All right, Mr. Ryan, I understand the position you're in. We've got pretty significant gap between now and when we appear next. I'm hoping a solution can be found. Perhaps appropriate placement can be found, and then he can move. But at some point, this issue needs to be joined. And as often in these cases, there's family nuance to the situation. It isn't just two names on a piece of paper, which isn't necessarily a defense, but it is something that is part of the facts of the case. All right, as we stumble our way through this with the judge hearing about 80% of what was said, and then 20% on repeat, we will continue this matter until Friday, April 24th at 11. We'll block out 11 to 12, so we'll have a full hour to address this. If we need more, I guess we go into the lunch hour. Hopefully an hour will be enough to do what we need to do. Mr. Ryan, anything to add?
No, Your Honor, thank you.
Ms. Kemple-Johnson, where are you located?
At the Kalamazoo office of Christ Enderly, Hutchinson Borzos.
Okay. Oh, it's a nice building. My financial advisor's in that building.
It is quite a nice facility.
Unlike me, you probably have a bathroom that works. And you know, boxes of stuff all over the place. All right, we'll address this matter on the 24th, and we'll see what you guys can accomplish in the meantime. Thank you all.
Yes, Your Honor.
Thank you.
Your Honor. Thank you.
This case has an interesting history. The defendant was subject to a judgment. He failed to appear for a discovery hearing and issued a bench warrant for his arrest. I set the bond at $2,100 cash, which may be applied to the debt less costs. The defendant got arrested, or at least contacted by the officers, and posted a $2,100 cash bond, which theoretically would be applied to the debt. This debt, as I indicated, is from 2021. We also have some legal services. And the defendant, between the time this order entered and the time he was picked up for contempt, filed for bankruptcy. That was on February the 9th. He got picked up I believe February the 3rd. So the court had a question as what to do with this bond. He owes the debt. There is a judgment against him. He was in contempt of court because he failed to appear for a discovery hearing. Several years passed before they finally caught up with him. And here we are. So Ms. Jensen,
Thank you for being here.
Can
Can
you
you
clear
the
the path for me on this?
this?
Thank you, Your Honor. I think the path that you just put on the record is exactly how it has happened. We do have a judgment that is several years old. We've been trying to collect on that for several years, in different modes, as including tax garnishments, and just the circumstances kind of snowballed this year where he was, contact was able to be made and bond posted. And then after that, we were made aware of this bankruptcy filing. So there is still the money owed. We have not received anything since that time. And so we're still trying to get our money that is to be collected from him. I don't know where the process is in the bankruptcy proceeding at this time, or frankly, what type of bankruptcy he filed. So I would just leave that to the court.
You filed a Chapter 7 bankruptcy. Ms. Mars, what's your position?
Your Honor, the filing date for the bankruptcy that I have is January 24th, 2026. He did file a Chapter 7 bankruptcy, which would put a stay against all of his creditors when the case was filed on that date. This was, my understanding is this is a general unsecured claim of the creditor. So that would be subject to the bankruptcy stay and then ultimate discharge of the debt if nobody objects to it. The 341 meeting with the trustee was held on March 10th. And so that has been concluded. There is now a 60-day waiting period since the conclusion of the 341, during which time creditors may object to discharge. I don't believe anybody has objected yet, but if no objection occurs within that time and he meets all the other requirements, then these debts would be discharged, as well as all his other unsecured creditors.
So my underlying question is, what do I do with this money?
I believe that since the bond was paid after the filing of the case, these would have been the assets and the exemptions are disclosed in the bankruptcy, and exemptions set at the time of the filing of the case. So whatever funds that Mr. Sonneville had on hand would have been disclosed in the bankruptcy and exempted. If those monies, if that bond money came from the assets he had on hand at the time or acquired after the filing, then that bond should be returned to him.
That's a bitter pill for FS&A. I'm not going to return the cost. There was a substantial cost in the Southwest Legal Services.
Your Honor, can you hear me?
Yes.
Okay. That bill was incurred because the homeowner, which was Charlie Dotson Enterprises, he was in Hawaii when that repair had to take place. That bill was sent to him and he told me he took care of it. That's why I never showed or anything else, because I never knew it was there. I never personally received anything from anybody that the money had not been paid.
Well, that's water under the bridge at this point. The judgment entered. It was defaulted, and there it is. I'm looking for my costs.
Your Honor, I don't know that it matters, but I don't see where we were ever notified of any bankruptcy filings. But from your Honor's court, Mr. Sonneville never listed us, or we haven't received any notice regarding him filing the bankruptcy for us to be able to make any claims. And obviously that is a debt that he knew he had.
Well, I have an order for closing due to bankruptcy stay that we got the stay and then we sent it to you.
Yeah, yes, that's what I received, but she's
That's the
indicating.
first notice you got.
Yes. Yes, we were never served with him filing any bankruptcy to be put on notice that he was filing for bankruptcy.
I'm not sure it matters because he did. And as much as I'd like to give you the money, I think that I'm prohibited.
Well, I'm just indicating, Your Honor, that as part of a claim, I think the creditors need to be put on notice that there's a bankruptcy claim.
Ms. Mars, what's yours to that?
Trying to look at the schedules, Your Honor. I do not see FNSA Electric LLC listed as a creditor. So I believe that what Ms. Jansen said, we will need to amend and give them proper service, which will extend their time to file any kind of notice or objection or something like that if they care to in the bankruptcy.
All right, well, I'm reluctant to simply give the money back to him. First of all, he was in contempt. And I don't know if we ever addressed that. But he has a number of other creditors. I'm about to give him we collected $2,100. We took out $62.50 for service, for Southwest Legal Services. So is it your position, Ms. Mars, that I must return this money to Mr. Sonneville?
I believe so, Your Honor. Because like I said, he did exempt any cash or other assets that he had on hand at the time, since his bond was paid after the filing. Any of those assets were exempt, and then any post-petition assets would have not been property of his bankruptcy estate. So I don't believe it needs to go to the bankruptcy trustee. I don't believe that it should go to just the one creditor. Even if it was released to the bankruptcy trustee, the trustee would then file a notice that she had money on hand, and all the creditors would then be able to make claims, and they would all get a pro rata share of what they're owed. So I think that if it did not return to the debtor, I don't believe it should go to just the one creditor.
No, I'm gonna return it to the bankruptcy trustee. Excuse me just a moment. I sometimes keep my phone in my pocket, which isn't always wise, but I use it to scan QR codes on suspect driver's licenses. And then it goes off with some random caller. All right, I'm going to return $2,037.50 to the bankruptcy trustee, and they can figure it out. and that is April Holst. 25 Division Avenue S Suite 500 Grand Rapids, Michigan. All right, Ms. Jansen, you've done an admirable job of trying to collect on this debt. This money will go into the pool that the trustee has. They left you off a list, so they'll have to amend that so you can make a claim. But I'm not gonna get sideways with the bankruptcy court. I'm sending the money to the trustee. It will be part of his assets, which can be divided to pay his creditors in this Chapter 7 bankruptcy. So, thank you all. You're all good to go. I'll do an order.
Thank you, Your Honor.
Ms. Holtz, can you hear me?
Yes, I can. Yeah.
Very good, thank you. As I said, I set this for a non-traditional landlord-tenant time. Usually we don't do these at 10 o'clock on Monday mornings, but because of scheduling pressures and some others, I set it for today. Brittany Holtz is here. Stuart Weiner is here, and Chris Corpening is about to join us from Memory Lane Mobile Home Park. This is the second hearing in this matter. The first hearing was March 30th. We determined at that time through March, rent and costs were $1,363.10. If we added April, we calculated an additional $975 for a total of $2,338.10, I think is what we had. So, Mr. Weiner, what's the status here today?
We thought that perhaps we would get payment, but we have not. So that $2,338.10 is accurate, but another $150, and that consists of I'm sorry, $75, consisting of a late fee of $50 and $25 for a pet fee. It now needs to be added, so the total is $2,413.10.
Could you repeat that number for me?
Last week, your plan was to try to get caught up on this and maintain your tenancy. What's your position here today?
Yeah, I am just waiting on payment for the jobs that I've done. Still should have no problem paying it. If I could just get that number one more time, the updated number.
Yeah, it's $2,413.10.
Okay, thank you so much.
No problem.
All right. I don't remember how I split that out with costs. I think costs were $257.10.
They were.
That's correct.
And she had cost of $256. All of that had been folded into the prior rent of March of $1,363.10.
All right. 2413 minus 257.10.
I could break it down for you further, Judge, if you would like.
Just a minute, I think I got it. So I just wanted a 2413.10 minus the cost of 257.10 is 2156. So the rent portion is rent and costs are 2156. And the costs are $257.10. So the total is $2,413.10.
That's correct.
Now, Ms. Holtz, you have 10 days from today to pay that. The good news is we're now into April. So we've included April in the total, a late fee for April and the April pet fee. But there won't be another month that will come due during this period. So you have 10 days from today to pay this or be subject to being evicted. But they don't have to evict you on the 10th day. 10 days from today would be April 16th. They have 56 days from today to ask for the writ of eviction. So you could agree to work with your landlord to try to get caught up on this. We had mentioned last week that you hadn't filed your taxes yet. Often people get a rescue line from a tax refund. But Mr. Weiner, I'd like you to send me an order showing that the amount to redeem is $2,156, including the pet fee and late fees. Court costs are $257.10. Total judgment is $2,413.10. The date for the writ is 10 days from today, which would be April 16th. And the appeal date is April 16th.
Will do, Your Honor.
Now, Ms. Holtz, my strong advice is you stay in contact with Ms. Corpening. She's been doing this for a long time. I say this a lot. It's easier to keep a good tenant in there than to move one out and move another one in. You're not substantially behind in your rent. You like to get caught up and you'd like to stay there. So they do have some wiggle room in here, but technically, unless you pay the entire amount by the date, which is April 16th, you are subject to being evicted. Partial payment will not prevent the writ of eviction. You have to pay the entire amount. And if you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. Do you have any questions?
I do not.
Mr. Weiner will send me the order. I'll sign it, send it to you. You stay in contact with your manager.
Thank you.
And I'm glad we were able to do this. I'm going to be gone a little bit, and we lost Good Friday. So we just need to be flexible to fit all our landlord tenant cases for April in.
We appreciate that, Your Honor. I have 2 words for you, Your Honor, and that is go blue.
Is what?
Go blue.
We're mostly green at my house. We have, I think, 11. We have, my youngest son is Michigan undergrad, Michigan law, so he's blue. And we're all rooting for Michigan tonight. We don't care about those people from Connecticut much.
That's right.
But I wish them well. They certainly came back from the Duke game. And the ladies' game was very fun to watch yesterday as well. So, all right, those are 2 good words to leave us by. I'll see you next time.
Thank you, Your
Got
Honor.
it.
Thank you.
Thank you.
Stuart.
Take care, everybody.